Welcome back to the show, everybody. Well, there's been a lot of talk about how the SEC versus Ripple case will resolve, and we don't know the answer, but I'll tell you this. I was fortunate enough to sit down with the one and only Thania Charmani from Winston-Strawn, who played a role as an amicus brief filing in the SEC versus Ripple, and has recently sat down and talked about also filing an amicus brief filing in the SEC versus Wahi, because it is very important. We're going to hear from her on both of those issues and her thoughts and observations. And will the SEC versus Ripple case go to the Supreme Court? Well, we sit down and talk with her. Somebody roll that beautiful intro.
Digital Perspectives with Brad Kimes. Come on in.
Welcome back to the show, everybody. Before we get started, I wanted to highlight this tweet right here from Molly Elmore. Give her a follow. We know Molly's been working with us so hard inside of the Digital Perspective Mastermind group, an instructor inside of there, and we have a weekly show that we do as well. I tell you, Molly is a rising star in this space and a force to be dealt with, no doubt about it. Shout out to her. But what she shares here, I think, is important for setting the tone of this conversation that I had with Thania Charmani. And Molly shares here, if Ripple were to win the case against the SEC, does that mean it's done? Maybe the Howie case went she says maybe, but the Howie case went 3 rounds before SCOTUS ruling in the SEC versus WJ Howie case 1946. Howie won the first case and the SEC appealed. Howie won again at the appellate level, and then it went further. And what's interesting here is you can see that Howie had not filed any registration statement with the Securities Exchange Commission. The SEC filed suit to obtain an injunction forbidding the defendants from using the mail and instrumentalities of interstate commerce and the offer of sale of unregistered and non-exempt securities in violation of the Securities Act 1933. It said the United States District Court of the Southern District Court, Florida, denied the injunction, and the United States Court of Appeals, Fifth Circuit Court, affirmed that, and the U.S. Supreme Court then granted Sarah, and I'm going to get the name of this right. Let me say this properly. Certiorari. That's how you say that. And basically what that means is it's a writ or order by which a higher court reviews a decision of a lower court in certiorari, okay? Well, what's interesting about that also is that it also says, in law, certiorari is a court process to seek judicial review of a decision of a lower court or government agency. Certiorari comes from the name of an English prerogative writ. It says here, issued by a superior court or direct the record of a lower court sent by a superior court review. Now, there was also something I wanted to share here where it says certiorari, simply defined, is a writ by which a higher court, such as an appellate court, reviews some of the lower court's decision. And then there's also this I wanted to share as well. And let me find it right here. It's an examination of an action of a lower court. But then it also says here, let me just find this really quickly for us here, because it is really important that I find it. Here it is right here. This is, what is the difference between certiorari and appeal? It says the distinction of each lies with what the directive of the petition party seeks. It says a writ of mandamus requests the Court of Appeals mandate that the trial court take an action. A writ of certiorari says requests that the Court of Appeals determine whether a court exceeded its jurisdiction. Well, that's interesting right there. So we understand what that means. Now, with that being said, let me roll this conversation with Thania and enjoy. All right, I am here with none other than Thania Charmani from Winston-Strawn, and let me tell you, she filed amicus brief filing for Val Hill Capital in the SEC versus Ripple, but now she comes back again. They file an amicus brief with Winston-Strawn in the SEC versus Wahi. Is that correct, Thania?
Yes, that's correct. We just filed an amicus on behalf of the Chamber of Digital Commerce in this pending action brought by the SEC in the for the Western District of Washington.
Well, first of all, shout out to Perry Ann Boring and shout out to you for stepping up to the plate again. And I got to throw it out to John Deaton, who's been out here getting it too. Give us an overview very quickly for those who don't know, Thania, of the SEC versus Wahi and what brought you into the mix here.
So in SEC versus Wahi, the SEC accused this former Coinbase employee, Wahi, along with his brother and their friends, of engaging in insider trading. And it is noteworthy that it's the first insider trading investigation involving cryptocurrencies.
Well, look, I mean, I went, as soon as I hear something like that, I think of the first unregistered ICO, which was Ethereum. But that's a conversation for another video. So, but tell me more about your filing of the brief in this case.
So, as you know, the Chamber is very involved in these litigations and in representing the interest of their members. It's a brief that needs to be before the court to kind of focus the court on what the SEC is trying to do here. They're bringing an action with allegations of insider trading, and the Chamber and the brief takes no position as to whether these allegations meet the legal standard. However, in doing that, they're labeling all underlying digital assets as securities.
Mm-hmm. One more opportunity for the SEC to try to regulate by enforcement and set precedent. Isn't that what we're watching here?
This is exactly what we're watching, and we're also seeing it in a way that has never been done before, because there are serious concerns here about their attempt to just label these assets as securities in the context not only of an enforcement action that bypasses any type of proper administrative procedure in rulemaking, but also against third parties who had nothing to do with creating or allocating these assets. So the allocators of these assets, the holders of these assets, have no way of rebutting the SEC's assertions on the nature of these assets, which could or could not fall under the purview of the SEC, but the SEC wants to bypass that part completely. In that way, destroying interest in those assets of innocent third parties.
Like secondary market sales and retail investors, Thania?
Exactly. And the asset itself. So the creators of those assets will suffer significant harm to goodwill. They'll face the prospect of class action lawsuits without having been given any proper forum to actually defend the classification of the asset. Same for the exchanges. Now they have an action pending. They have to confront the threat of regulatory actions and private litigation, and they might feel compelled to delist those assets that were targeted by the SEC, but no one is given an opportunity to defend their status. And at the same time, you have holders, innocent third-party holders of those assets that use them for consumptive uses, that will see the liquidity of the assets and the value of these assets destroyed. So who are we trying to protect here? Because it's the so-called investors by the SEC that are being harmed.
I completely agree. And when you make the point about, the people being harmed that have the assets that are trying to use it for consumptive use, what does this mean for the opportunity for the United States to play a leading role in innovation in this technology going forward?
I think it's extremely harmful, and it's something that not only industry participants or legal individuals who are involved have said a million times. You have SEC commissioners who've said this. Commissioner Pierce has repeatedly said that we are killing innovation here. The truth is that that type of regulatory uncertainty and the threat of these collateral consequences will necessarily lead to a world where innovators just don't want to be in the US. If you want to develop a project like that, you will not stay in the US. You will go offshore, and at the same time, you take everything out of the US economy, you take it out of the market, but also you reduce the United States' reach in regulating. So you're taking protection away from the investors.
Well said. And what are the next steps, Thania, for the SEC versus Wahi and your amicus brief?
So the brief has been filed with the courts for leave of court to submit this brief. We're hoping the court will see the importance of the brief in highlighting the SEC's approach here. The briefing on the motion to dismiss hasn't been concluded yet. The SEC hasn't filed its opposition, and then defendants will also have the opportunity to file a reply, and then we'll wait for a ruling. It's going to be an interesting decision, and our brief also tries to highlight another issue with the SEC's approach here. The fact that they don't have clear authority to be in this space, at least not in the way they're trying to broadly regulate by enforcement. Congress has never authorized the SEC to do this. And you see that because the CFTC, for example, is coming out. Commissioner Pham came out the day that the SEC filed SEC v. Wahi and said that this is improper, that what the SEC is doing is exceeding its jurisdiction. And this is not surprising. Congress is currently considering legislative bills that would, at least in part and in some cases in whole, divest the SEC of such jurisdiction. So it is absurd to assert that the SEC has clear congressional authority here. And in the past few years, we've seen that the Supreme Court has very clearly expressed concerns in cases where agencies take such a broad approach to regulation absent clear authority. It's what we call the major questions doctrine, which says that in cases where you have significant economic consequence based on the reach of an agency, then the court should hesitate to recognize that type of authority absent clear congressional authorities. And underlying the rationale is that you need to have clear understanding of legislative intent in order to allow an agency to just affect the economic realities in that way.
So am I correct that you're citing, I believe John Deaton had mentioned it, it's the EPA versus up at the Supreme Court case. Is that the case you're mentioning?
Yes, it's
okay.
But it's the West Virginia via EPA, which is from 2022, but there are many other cases,
okay,
including the Alabama Association of Realtors versus the Department of Health in 2021, Gonzalez v. Orr in 2016. The court has said time and time again that the agency cannot do this, and Congress cannot delegate decisions of such economic and political significance without clearly saying that.
Well, speaking of the Supreme Court and obviously them being in a position right now where they are not afraid to set a government agency back in its own lane, which is kind of refreshing. Let's move now to the SEC versus Ripple case. There's been a lot of opining about where this case could go, everything from settlement to split rulings to appeals to Supreme Court. Is the state of this crypto space such that one of these cases, albeit Ripple or be it Wahi or something, make its way to the Supreme Court? Do you see a path like that as possible?
Yeah, Brad, I certainly do. And I think that could provide some clarity. I will say that we still need Congress to act, because all of these decisions are based on the Howey test, a test that was laid out in 1946 that could not have been articulated with the nature of digital assets in mind or the underlying blockchain technology. But I do see one of these cases getting to the Supreme Court, and then the court will have to grapple with the fact that that test is possibly inapplicable.
I mean, that is, to me, well, listen, I really obviously follow, Ripple and XRP closer than other cases that are happening. So when I speak to this, obviously I'm biased in what I understand versus what I don't. So I want to be clear for audience members that hear that. But, when I see this, there's a lot about this case that suggests to me, and you and I have had conversations in the past. I know when you guys had filed the amicus brief with the SEC versus Ripple case, I had suggested to you at that time that, Ripple and SEC could come out of this with both partial wins in some cases, like John Deaton and other legal analysts have suggested. And then I feel like, one of the parties could choose to, let's say it's the SEC, could choose to appeal that decision partially, and then it go to appellate court. But Ripple could continue forward with a great decision for them and using XRP, U.S. adoption, and then it goes to appeals court, and maybe then it goes again to the Supreme Court. And the entire time, Ripple could be going through mass adoption, growth in the U.S., XRP being used as a payment token as it is intended to be. And then ultimately, 2-3 years later, you get a decision and a final ruling from the Supreme Court. I mean, is that a path that's so hard to believe, or is that something that's certainly plausible there?
I think it's certainly possible, and I think that ties the reality of what you just described on how the network could change, on how the utility could grow even more widespread, is exactly why so many participants in the industry are talking about the framework discussing assets that form from a security to a non-security. It could be that the court decides to say that at this point, XRP cannot constitute a security based on the decentralization level that it has achieved based on the consumptive uses that are undeniable in the case of XRP. Now, as to how this moves through the court, we need to be mindful about the fact that the court is reviewing the record before it. And when the district court renders a decision, then the appellate courts are going to review the accuracy of this decision based on what the district court was considering at the time. So we have an industry that's moving extremely fast, that's developing and evolving every day, and we could have a decision that at that point is not going to be directly relevant to what's happening in the market.
Well, you make so many good points there. I just want to go back and touch on the fact that Hester Peirce's safe harbor rule, I think, could solve like 99.99999% of all of this if they would just implement it, and then innovation could thrive and flourish, and they could really tailor that 3-year period to put some benchmarks in there for all of the startups to make sure that they hit these watermarks to become decentralized by the end of that 3-year period. It just, I don't know. It just makes a lot of sense to me, but I mean, what do I know, right? But, but coming back to the SEC versus Ripple case and where it is now, the number one question, and I'll put it to you, and obviously you field it however you would like, but the number one question that I get every day on my channel is, will retail investors be not harmed, but be placed in such a way that they can't get the asset because the consumptive use of XRP is really through on-demand liquidity and RippleNet and not through the retail investor market, because that's the speculative side. Do you have any thoughts on that, Thania?
So I can speak to you from the perspective of the legal aspect of how this harms retail investors. And that's something that's common to Ripple, that's something that's common to Wahi. It's certainly possible that while the SEC is bringing these actions in such an aggressive manner, basically seeking to just shut these projects down completely, because the minute you regulate them in that way, then you take away the consumptive uses. Yes, retail investors are being harmed and will be harmed in the end, because the SEC is now seeking to also say that they have authority in the secondary markets as well. So their regulatory authority is so expansive and so broad that based on these actions, no one is safe, no one should feel comfortable holding their digital assets. And these are all innocent third-party holders that, looking at the SEC's guidance in the past few years, the speeches that we've seen have said that, look, if it's a consumptive use, then it cannot be a security.
Exactly. I think you can't say it any more concise than you just said it. And I've heard John Deaton say it. I've now heard you say it. And, you know, it just... you know, when you understand it that way, how could anybody, I mean, you know, who am I, right? But I mean, how could anybody rule that secondary market sales constitute an asset, whether it be XRP or some other asset, as a security is beyond me.
And this is something that we are discussing in the SEC Wahi brief, because although we're not taking a position when it comes to the insider trader allegations, the secondary markets aspect of it is just an absurd assertion by the SEC. The fact that secondary market trades of digital assets could be considered securities transaction is just deviating from the way the SEC has been operating in the traditional markets. So we're seeing here that instead of limiting their authority, that when they don't have congressional approval to exert any type of authority here, they're actually seeking to expand it. Secondary market trades, by definition and the way they operate, cannot constitute securities actions.
Amen. Well, Thania, listen, I say it, and I say it for myself. I say it for my audience. We are extremely grateful for you. We're certainly grateful for John Deaton and all that you all are doing to really take a stand to give all of us a voice, because without you and John Deaton and others taking action, the secondary market retail investor does not have one. So thank you very much. Final thought, Thania.
I think we should all be very careful in the way we approach these cases, in the way we're defending actions against the SEC. We have to work with the regulator. We have to find a way to have a framework that's clear for market participants, for the allocators. We see that market participants are showing up. Valhill Capital, the Chamber of Digital Commerce, is doing amazing work. We should all support the industry and try to find a way to regulate and support innovation and support something that's revolutionary in today's economy.
Well said, Thania, and hats off to Perry Ann Boring and the Chamber of Digital Commerce and all your work, Thania. Please come back and talk to us when we get some motion on either of these cases. We would be glad to have you.
Anytime, Brad. Thank you for having me.
Thank you. There you have it, ladies and gentlemen, and I just want to thank Thania one more time and Chamber of Digital Commerce, Perry Ann Boring, and all their efforts in the SEC versus Wahi case. We got to say a big thank you to John Deaton and his continued effort as well. Look, that's going to do it for me. Not financial advice from me or anyone else. It's just our digital perspectives. I'll catch all of you on the next one.